Should I wait for the spousal permit to be extended before informing Home Affairs that we are divorced? The short answer. The court ordered that a foreign ex-spouse should be allowed to live and work in the country to discharge parental duties. The whole question: what happens to the extension of the spousal visa that my partner applied for on 1st April 2022, which is still being processed by Home Affairs, and to their application for permanent residence which they applied for on 17th June 2022, which is also still being processed, now that I am in the process of divorcing them, as it is a religious marriage? I am waiting for an appointment with the Muslim Judicial Council to sign a divorce certificate. I am not sure whether to wait for the spousal permit to be extended before informing Home Affairs that we are divorced. We have an 11-year-old daughter, and we have lived together for 11 years, and married for 2 years. The long answer: divorce laws explains that the default position of Home Affairs is based on Section 43IA of the Immigration Act, which says that a foreigner shall abide by the terms and conditions of his or her status, including any terms and conditions attached to the relevant visa or permanent residence permit, as the case may be, by the Director General upon its issuance, extension or renewal, and that status shall expire upon the violation of those terms and conditions. In practice, divorce law says this means that where the foreign husband or life partner has one or more visas that connect and restrict his temporary residence to being in South Africa in order to accompany his wife, that visa will certainly lapse on the date of the divorce. Permanent residence is granted under Section 26B of the Immigration Act, which states, "The Director General may issue a permanent residence permit to a foreigner who has been the spouse of a citizen or permanent resident for 5 years, and the Director General is satisfied that a good faith spousal relationship exists, provided that such permanent residence permit shall lapse if at any time within 2 years from the issuing of that permit the relationship no longer exists, except in the case of death." In terms of Section 26B, there would be no impact on the permanent residence and subsequent green ID if the relationship ended more than 2 years after the permanent residence was issued. If it ends within the 2-year period, either party could inform the Department of Home Affairs, but it is usually the South African citizen, initial permanent residence permit holder spouse, that the application had been made under, who attends at a regional office to inform Immigration Inspectorate of the breakdown of the relationship on affidavit. If the foreign spouse's visa has lapsed as a result of the divorce, then, if the foreign ex-spouse wishes or needs to remain in South Africa, their first step will be to seek legalization. If that is approved, they can then start with the visa application process,